Mr Singh, just before you get going, first of all, I hope you've all been told that we're intending to rise by 3:30 today. As a knock-on from that, unless anyone objects, it seems to be sensible to break at, say, 12:45 rather than waiting until 1 o'clock. And the other thing is that we've been supplied with a very limited amount of without prejudice save as to costs documentation. To be on the safe side, none of us, I think, has looked at it yet, but I assume from the fact that it's extensively referred to elsewhere that no one has any difficulty about us looking at it.
I think that's right, given the cost judgment, my lord.
Yes. No, that's helpful, thank you.
My lords, good morning. I appear, as you know, with Miss Ingle on behalf of the appellants, that's Quantum Care Ltd and its ultimate owner, Mrs Marg. Mr Mill, King's Counsel, and Mr Price appear on behalf of the respondent, Mr Lalit Modi. And as your lordships know, this is an appeal against part of the order of Mr Murray Rosen, Queen's Counsel, then sitting as a Deputy High Court Judge, whilst he found in favour of Quantum Care and Mrs Marg in relation to the breach of contract claim against Mr Modi. He dismissed the deceit claim. Now, my lords, may I begin by raising 2 points of housekeeping. The first is that your lordships will have seen that there are 2 supplemental bundles. One is agreed and one is unagreed. And we respectfully seek permission to rely upon the unagreed supplemental bundle. There's been quite a lot of correspondence about this, but if I can cut to the chase.
As a matter of fact, I haven't checked this with my brethren. I suspect we have all looked quite extensively at the unagreed documents bundle. And so, unless Mr Mill has any particular objection to it, then...
I have too.
Yes.
I'm grateful. My lords, the second point is another short one. We noticed in our preparation for today that the core bundle, and indeed I think all of the bundles, have black and white documents. And we would respectfully suggest it may be easier for your lordships to look at 2 documents in particular, which I intend to refer to this morning, the investor pitch deck and the leadership board, in colour rather than black and white, and so we've just produced. It has the same pagination, but it may assist your lordships too.
And I would be staggered if Mr Mill had any objection to seeing the coloured versions. No.
My lords, in that case, I'll start to open the appeal. So, my lords, the deceit claim, as you know, arose out of a meeting between Mrs Marg, her husband Mr Marg, and Mr Modi, which took place on the evening of the 13th of April 2018 and went on until the early hours of the 14th of April. The meeting, the venue of that meeting was Mr Modi's hotel suite at the Four Seasons Hotel in Dubai, to which he had invited Mr and Mrs Marg. And in a nutshell, what was alleged was that at the meeting, Mr Modi made a number of statements which were intended to induce Mrs Marg to invest in a healthcare business called Care, which Mr Modi had been trying to develop since 2016. And those statements were to the effect that a number of well-known and influential individuals had already agreed to act as patrons of Care, to participate in its management as so-called leaders, and to act as brand ambassadors for Care. And also that a number of those individuals had made substantial financial commitments to the business. And my lords, those statements were alleged to have been made orally and in writing, including through 2 documents, which the judge did find were used by Mr Modi at the meeting when making the pitch. That's the investor pitch deck and the other document, which has been referred to as the leadership board. Now, my lords, as the judge noted at paragraph 30 of the judgment, and this is not the subject of any challenge on this appeal, if the statements were made, then they were false, and Mr Modi would have known they were false, because at the time of the 13th of April meeting, in fact, with 2 exceptions, that's Dr Greco and Professor Fuchs, none of the individuals had in fact agreed to be involved as patrons, leaders or brand ambassadors, and none had agreed to provide funding. Now, as your lordships will have read, by the end of the meeting, Mrs Marg's case was that she had decided to invest $2 million in return for 2% of equity in the business, and she subsequently incorporated Quantum Care Ltd for that purpose at the beginning of July 2018, and then later in July, Quantum's parent company, Tamares, borrowed $2 million from a company owned by a member of her family, Dunbridge. Quantum then went on to invest the $1 million in Care in November 2018. and the remaining $1 million was to be drawn down by Ironcare as and when the business needed it. But ultimately, those additional funds were never invested because the business didn't get off the ground. Now, your Lordships will have seen reference to the contract claim. Mr and Mrs Marg met with Mr Modi in April 2019, and he agreed to repay the $1 million investment. In fact, he only repaid $200,000 and didn't return the balance. And so the judge has ordered the return of $800,000 plus interest. But that was not the only financial loss which Quantum suffered as a result of the deceit. And in particular, your Lordships will have seen that Mrs Marg's case is that but for the fraudulent statements made by Mr Modi, she would have invested the full $2 million via Quantum in a company called LiveSpace, or alternatively a company called B1T, both of which have gone on to be very successful. Now, my lords, the key findings in relation to the deceit claim were threefold. First, that at the meeting in Dubai, Mr Modi did not make statements in the terms alleged. Secondly, if they were made, they would have been knowingly false, but they didn't induce Mrs Marg to make the investment. Strictly speaking, the judge has found that the presumption that the victim of a fraudulent statement was induced was rebutted on the facts. And the third key finding was his dismissal of the claim for consequential loss based on the alternative investments which I've just referred to. And by the present appeal, my lords, we challenge the judge's conclusions in relation to each of those issues. In relation to the first and second issues, namely whether the representations were made and whether the presumption of inducement was rebutted, I just want to say this at the outset. We obviously recognise that it is a rare case where an appellate court will interfere with the findings of fact made by a trial judge who has seen and heard from the witnesses. We accept that, but we do submit that this is an exceptional case, and on the facts of this case, the judge reached an unreasonable decision. And we make a number of criticisms of the judge's reasoning on the first and second issues, which I will obviously develop in due course. But just to foreshadow, give an outline of the key points, in relation to the first question of whether the alleged fraudulent statements were made, the judge's ultimate conclusion was that Mr Modi did not say that the relevant individuals had already agreed to be involved. He only said that they were part of his vision for the future. That's what the judge accepted from Mr Modi. And the judge accepted that version of events, even though Mr Modi said he didn't recall the meeting, even though the judge found Mr Modi to be an unreliable witness whose relationship with reality was fluid and sometimes even distant or at least secondary. That's paragraph 60 of the judgment. And even though, my lords, there was a significant body of evidence that Mr Modi did in fact make the statements alleged, and that's not only the evidence of Mr and Mrs Marg, but also, as I'll show you, some of the oral evidence which Mr Modi himself gave to the judge in relation to, for example, the Sheikh Nayan and Dr Shinawatra, which was precisely to the same effect as the statements alleged by Mrs Marg and Quantum. Moreover, my lords, I will show you the WhatsApp message, which you've probably seen reference to in the judgment, a WhatsApp message which Mr Modi sent to Mr Marg in August 2018, referring to Kofi Annan, and we submit that that message only makes sense if Mr Modi did indeed make the statements alleged at the April meeting. And my lords, more generally, we submit that the judgment is incoherent because, as I will show you, in some places, the judge finds that Mr Modi didn't make the statements alleged by Quantum and Mrs Marg, but then in other places, he seems effectively to accept that he did make the statements, but then says Mr and Mrs Marg were not gullible individuals and shouldn't have believed Mr Modi. And we say that is an erroneous conflation of two different issues, whether the representations were made and whether or not they were relied upon. And I will also show you, my lords, that there are some clear errors on the face of the judgment, where the judge has said certain things about the evidence, where in fact, if I show you the transcripts, you'll see they're plainly wrong, what the judge says in relation to at least two important issues. So, my lords, by way of introduction, we do say there are some real problems with the judgment in relation to the first issue, whether the representations were made. And we also say his conclusion that the presumption of inducement was rebutted was an unreasonable one. But, my lords, so far as the third issue is concerned, that's consequential loss, the nature of our criticism is different. We say, in a nutshell, the judge dismissed the claim for consequential loss on a point that was never pleaded by Mr Modi. And we say that was something which the judge was not entitled to do, to find against Quantum and Mrs Marg on the basis of an issue that was never pleaded. And that's a relatively short point, but an important one. So, my lords, I will develop all of those points, but we do respectfully submit that this is a case where a retrial is justified. That is, of course, in some respects, an undesirable outcome given the additional burden to the court and to the parties. But as the court has acknowledged in a number of cases, including the Icon case, which we've included in the bundle at tab 6, the greater unfairness would lie in letting the judgment stand as it is. So, my lords, I intend to address you in the following way. First, I'm going to address you a bit further on the background and show you some documents. Then I will make submissions about the judge's conclusion that the statements were not made in the terms alleged, and I intend to spend the majority of my time on that issue. And then I will address you on the question of whether the presumption of inducement was rebutted. And your lordships will have picked up that the judge's conclusion on that issue seems to have strengthened from the first judgment to his second judgment. And then I'll deal with the consequential loss issue, and then finally the utility of a retrial, because as your lordships have seen, a major point that is taken against me is that there will be no practical utility in sending this case back. And we say that's wrong for a number of reasons, which I will develop, but consequential loss being the obvious one. But in fact, there are also other points in relation to costs and interest. So, my lords, can I start now with the particulars of claim, please? Core Bundle, tab 9.
Can I just ask, if you succeed in your appeal, you're asking for a retrial of everything, are you?
Yes, my lord.
Yes, because the appellant's notice has an order asked for in which we're asked to uphold the claim in deceit. That's going too far, is it?
My lord, we're seeking a retrial.
Yes.
Could I start by just showing you the way in which the representations were pleaded in the particulars of claim? It's Core Bundle, tab 9. I'd just like to show you the particulars of claim because these are not set out clearly in the judgment, so that you can see the 4 categories of representations which were alleged. If I could start at page 118, please, paragraph 8 of the particulars, you'll see the heading, the representations made by Mr Modi. And you'll see the first reference there to the presentation. That's the investor pitch deck, or IPD. And you'll see the presentation was oral and accompanied by slides. And then you'll see at paragraph 10, the first of 4 categories of representation. By showing the slides, he represented that the following individuals were patrons of Ironcare. And you'll see the individuals referred to, including Kofi Annan, who I'll come back to. Then at 11, the allegation of falsity. And then at 12 and 13, we see the alleged leadership representations. Now, the difference, just so that your lordships see this, between 12 and 13 is that the individuals in 12 are said to be individuals who had agreed to perform specific leadership roles, whereas the individuals in 13, it is said, you'll see this in paragraph 13, specific roles were not attributed to those individuals. So that's the difference, but ultimately it's the same point. And just to draw out some key names that I'll come back to, at 12.1, Sheikh Nayan, 12.2, Dr. Shinawatra, and 13.3, just to pick out some relevant ones for the purposes of my submissions, Gaston Brown, the Prime Minister of Antigua, and 13.6, Harish Salve. So those are the leadership representations. And then the allegation of falsity at 14. And then one sees at 16 a reference to a pack of documents. That seems to have been referred to at the trial as the leadership board, and that's the nomenclature that I will adopt this morning. So that's the pack of photos of the individuals and various celebrities, including Roger Federer and Cristiano Ronaldo, who are described as brand ambassadors. And then you see at 17, they're not defined, but these are the brand ambassador representations, as it were. And an allegation of falsity at 19. And then 20 and 21 contain the fourth category of alleged representations, the funding representations, which were alleged to have been made orally. So the others are a combination of written and oral representations. The funding representations are said to be oral, and then your lordships will see what the contents of those representations are at 21, and you'll see it's it's Sheikh Nayyan 21.1, Dr. Shinawatra 21.2, Prime Minister of Antigua, it's Gaston Brown 21.4, and then a reference to the brand ambassadors 21.5, and then the falsity allegation in that respect at 22, and then at 23 there's reference to an information memorandum. Now, in fact, by the time we get to the reply, it's accepted that this is circulated on the 16th of April, so 2 days after the meeting. But there was also a set of representations, as your lordships will see, alleged in relation to the information memorandum. I just mentioned that because one of the points I'll make later is that the judge fails to deal with any evidence in relation to the cross-examination that took place on the information memorandum. That's a point I'll come back to. So that's, my lords, the way in which the case was pleaded. Can I now show you the investor pitch deck, which was in the unagreed supplemental bundle 1. And your lordships will know from reading the judgment that a major issue at trial was whether, in fact, this document, or some version of it, at least, was used by Mr Modi as part of his pitch. That was a hotly contested issue at trial, and as your lordships will have seen, the judge ultimately rejected Mr Modi's evidence and case as to that, and held that this document was shown to Mr and Mrs Marg. And I just want to show you some aspects of this document. So if I could start at page 1, you'll see world-class image-guided radiotherapy solutions. And then page 2, just to show you in the bottom left-hand corner of the slide, investor pitch deck. Now that wording appears on almost all of the subsequent pages. Obviously I won't take you through that, but I do place great reliance on the fact that this document is called an investor pitch deck. Now, if we then pick this up at page 5, you'll see the beginning of the section headed The Patrons. And just pausing there, it doesn't say the proposed patrons or the intended patrons or the vision for patrons, it's the patrons. And then you'll see the individuals that we've already seen reference to in the particulars of claim. And just to show you page 10, Kofi Annan, listed there as a patron. And then at page 11, we see the beginning of the section concerning the leadership team. Again, no reference to vision or proposed or intended, it's the leadership team. And then at page 12, we see a reference to Sheikh Nayyan, 12 and 13. His position is stated to be co-chair and trustee. Over the page 14 and 15, we see Dr. Shinawatra, co-chair and trustee. And again, I won't take up too much time, but just to bring out the same individuals that I emphasised in the particulars of claim. Page 18, one sees Gaston Brown, the Prime Minister of Antigua. Page 22, Harish Salve. Page 23, Mr Modi himself. And then, if I could ask you to turn up page 115. The heading Iron Care Management Team. And page 116, if I could ask you to look at 116, the Iron Care Chairman, Dr. Shinawatra. And my lords, if I could ask you to look at the final paragraph, and indeed the final sentence, he is described there as the chairman. He is chairman of Iron Care Limited. And we do submit that the use of the present tense there is significant. Now if I could show you the leadership board, which is in the agreed supplemental bundle behind tab 2. Your lordships may have looked at this already, but it's essentially a pack of photos. If I could just again pick out some key pages. So starting at page 6, we see reference there, a picture of Sheikh Nayan. Page 7, Kofi Annan. Page 8, Dr. Shinawatra. Page 12 is Gaston Brown, Prime Minister of Antigua again. Page 16 is Harish Salve. And then page 39, you'll see the page which has a section beginning Brand Ambassadors. And again, just to take this quickly, 46 and 47, you'll see the pictures of Roger Federer and Cristiano Ronaldo. So, my lords, having shown you those materials which are referred to in the particulars of claim, I'd like to turn to the first substantive issue, whether the alleged oral and written statements were made by Mr Modi at the meeting in the terms alleged. And I'm going to deal with two issues together, whether the statements were made and also whether they were made with the intention to induce Mrs Marg, because essentially the evidence is the same in relation to both points, or my submissions would be broadly the same.
I'm sorry, Mr. Singh, can I just take you back to the document we were just looking at?
Yes,
the
of course.
Brand Ambassadors.
Yes, of course.
Just, I see that page 46, there's a picture of Roger Federer, for example, and you showed us that. And Cristiano Ronaldo at page 47. But just flicking through this, we see Neymar at page 48, Messi at page 49. What was the submission? Were these all represented to be brand ambassadors?
That was the way in which the case was put at trial, yes. The reason I focused particularly on Cristiano Ronaldo and Roger Federer is there was the cross-examination at trial didn't run through every individual in these documents.
Right.
Those two were referred to in the cross-examination and indeed the judgment. And so when I'll make my submissions later, those two will be the subject of something I'll say later. But no distinction was drawn between the individuals that you see in that section. My lords, I was just explaining that in relation to the first part of my submission, so whether the statements were made, I just wanted to say that I'm going to deal with two things together, whether the statements were made and whether they were made with the intention to induce. And the reason I emphasise that, my lords, is because the judge made no findings at all in relation to the intention to induce issue, which is one of the criticisms we make, and it's common ground that the judge made no findings in relation to that second issue. They are, of course, distinct questions, but one of the criticisms we make is that he conflated many of the legal issues which arose, and this is just one example. But I'll treat them together because, for brevity, really, and efficiency. Now, in relation to whether the statements were made, can I start here by showing you what Mr Modi's case was at trial? And beginning with the defence, please, which is in the core bundle behind tab 10. if your lordships could pick this up at page 134, which is the first page of the defence. So your lordships will see the summary of the defence at 1A. It begins by saying the claimant's case on reliance is hopeless, and then the claimants have failed to adequately put a case of dishonesty. And then at 7, paragraph 7 on page 136, this is what Mr Modi was saying about the actual management team, and then there are later references in the defence to Mrs Marg knowing that the only people actually involved in the management were these individuals. Paragraph 8, Mr Lalit Modi intended to, and in many cases did approach, his many contacts and acquaintances of an international standing. Now, just pausing there, we say that whether in fact he had made any approaches is irrelevant, because the statements alleged were to the effect that they had already agreed, these individuals. So whether or not they had been approached is a red herring, we submit. And you'll see at the end of paragraph 8 over the page, many people expressed an interest in participating financially in the project. And then in paragraph 9, he says that Mrs Marg approached him. That point, in fact, was not pursued at trial. But more importantly, for present purposes, the second part, or the final sentence, in fact, of paragraph 9, in response to that request, he shared his vision, and that's a word that you will see repeatedly in the documents, and we'll see that in his oral evidence. So his case was, he was only ever describing his vision, i.e. a future vision. And we'll see this again if one looks at paragraph 19 on page 141 of the bundle. The meeting is admitted, averred that Mrs Marg was accompanied by her husband, Mr Marg. The purpose of the meeting was to introduce them to Mr Lalit Modi's vision for Iron Care. And then at 21, the personalities mentioned were illustrative. This is in relation to the patrons. The personalities mentioned were illustrative. As Mrs Marg and Mr Marg knew, Iron Care was at an early stage of development and had no patrons. So in other words, common ground that if that representation had been made, it was false. And then what he says is he intended to approach some or all of those people. And to the extent that during this meeting he represented that he had such an intention, such representation was true. And then 23, your lordships will see again, this is in relation to the leadership individuals. The people mentioned were illustrative of the kinds of person he envisaged. Any statements concerning such people were at most statements of intent. And then at 24, it's pleaded that in any event he had in fact approached. And as I say, that doesn't in fact matter if the statements were made in the terms alleged. 27, you'll see this is in relation to brand ambassadors, or the leadership pack. It's denied that provision of a photograph is capable of amounting to representation. In any event, the people photographed were illustrative of the kinds of person. And that's a point, a word that I emphasise because I'll come back to that in my submissions. And then at 35, just wanted to show you that as Mrs Gilmarg knew, Iron Care at the time had no directors or office holders at all. This is in relation to the information memorandum. It's said to be a proposal only. So that's really the way in which the case was pleaded. And I'd emphasise the words vision and illustrative details. That's what Mr Modi was saying. So I didn't say that these people had agreed. In fact, they hadn't agreed. It was all about vision and illustrative details. And then if we can see that also, my lords, if I can show you quickly his witness statement, his first witness statement, which is in agreed supplemental bundle tab 11. If I could begin at paragraph 21. In respect of Iron Care, I told them the background to the project. And then he says, we were all sitting there together and I was talking them through the project, what my vision was and my plans. So again, reference to vision. And at 23, I don't recall referring to any of the individuals listed in the particulars of claim other than Dr. Greco and Dr. Fuchs. It was a general discussion about my vision and plans. And then 24, he denies various paragraphs of the particulars of claim. So I never said that to them. I never said anything about this, and so on. And then 25, I do not believe I made any statements amounting to representations. We had a general discussion about the vision and strategy for the iron care business. And so, again, my lords, it's being said this was all forward-looking. Paragraph 26, second sentence. This was a start-up, a vision. And 27, I believe what I said to be true as I was setting out my vision and wish list. And then what he did in his witness statement at paragraph 28 is he set out his purported recollection of the involvement of all of the individuals. And I won't take up time going through that. But it's clear from subparagraphs A to E, where he deals with the patrons, that in fact none of them had agreed. He wasn't even suggesting that they had agreed in his witness statement. In F and G, he refers to some discussions that he'd had with Sheikh Nayan and Dr. Shinawatra. But again, he's not saying that in those paragraphs that those individuals had in fact agreed. He's just referring to some discussions that he had had. And then, perhaps if I just show you the paragraphs in relation to the individuals I've already highlighted. At subparagraph Q, on the opposing page, Gaston Brown, Prime Minister of Antigua, he's a dear friend of mine. He agreed to grant Iron Care the land, but we decided to pull out. At subparagraph T, Harry Salve, we spoke with him about it, and he said he'd be happy to look at it, but again, no suggestion that he in fact had agreed. And then Roger Federer at the bottom of the page, and Cristiano Ronaldo. No suggestion that they had agreed. And in fact, that's also an answer to Lord Justice Singh's question as to why particular emphasis was placed at trial on those two brand ambassadors. I think maybe because those were the two highlighted by Mr Modi in his witness statement. And then at paragraph 30, he refers again to a wish list of people. This pitch book changed over time. So note that he's referring to it there as a pitch book, but it was a vision, a wish list, and the information memorandum he also refers to as a vision. So that is the way in which the evidence in chief went. And when it came to trial, your lordships will have seen the judge alluding to this, but Mr Modi's recollection was very poor indeed. And if I just show you a couple of references in the transcript so that you can see exactly what he said about the extent or otherwise of his recollection. This is in the unagreed supplemental bundle behind tab 4. And the first reference, my lords, is at page 325 of the bundle, which is page 99 of the transcript. So what he was saying at lines 5 to 7, today sitting here, I don't know exactly what happened, but we met and I discussed my vision with them. It's all I remember. And similarly, if one moves forward to page 155 of the transcript, which is 339 of the bundle, at lines 12 to 15, the judge himself says, "This is the impression I'm getting from you. You can't actually recall much about what you told them regarding the facts of the business." Mr Modi says, "Correct." So, my lords, just pausing there, Mr Modi clearly couldn't recall very much at all about the meeting, but his position was clear. Notwithstanding that he couldn't recall very much, he denied that he ever made statements in the terms alleged. But importantly, because when I come back to looking at the judgment more closely, importantly, my lords, there was a single line of defence being run, which was he denied saying that the individuals had already committed. He said the details were illustrative only and part of his forward-looking vision. And I will come back to that because your lordships will have seen how the judge dealt with this in his supplementary judgment or his second judgment. But it's important, we say, to note that Mr Modi was not drawing some distinction between vision and illustrative details. His case was just, I didn't say the individuals had already agreed to participate. I was just saying these were people that I wanted to approach in the future as part of my vision or wish list. Now, my lords, can we look at what the judge held in relation to this? So, the first judgment is in Core Bundle Tab A. And I know that your lordships will have spent time with the judgment, but if I could just highlight some key paragraphs on this question of whether the representations were made. Beginning at paragraph 19, you'll see the reference to Mr Modi not having a clear recollection, but nonetheless denying making the representations. So that's the point I've just made. Paragraph 30, again, just for your lordship's note, that's the paragraph where it said that if these representations were made, they would have been false and he would have known it. And as I say, no challenges made in relation to that paragraph. And then paragraph 60. Mr Modi was an unreliable witness, very poor recall. And then your lordships will see the reference that I mentioned earlier, attempting to focus on objective reality with which his relationship seemed fluid and sometimes even distant or at least secondary. And then at 62, in the final sentence, I just want to highlight that the judge says here, neither Mr nor Mrs Marg seemed to me at all gullible, and despite Mr Modi's past achievements and connections, I would expect them to have taken some of his possible boasts and puffs, as I did, with at least a pinch of salt. I'm going to make a submission about this reference to boasts and puffs in due course. And 69, again, just so that your lordship can see this in context, at 69, the judge accepts that the IPD was in fact used at the meeting, contrary to Mr Modi's account. That's 69 through to 71. And then the key findings, my lords, on this question of whether the representations were made begin really at 78. It's really 78 through to 89. And if I could just pick up some key passages. At 83, again, I'm going to come back to this in my submissions, but the judge refers to Mr Modi having given a confused account of what was vision and what was reality. And it was unlikely that the Sheikh Nayan or Dr Shinawatra had definitively agreed to lead Iron Care. So I'll come back to that, but the judge has found that there was a confused account given of vision and reality. 84, Mr Modi didn't put much of a positive evidential case, other than saying, for example, that at the initial meeting, he and the Margs had a general discussion about the vision, and your lordships will recognise the quotation. I've shown you that. It's paragraph 26 of Mr Modi's first witness statement. And then, again, just to highlight, at 87 is the reference to the Kofi Annan WhatsApp message, which I'll come back to. Just draw your attention to the reference there, to where the judge says the message, whilst consistent with Mr Modi having previously so misdescribed Mr Anand, which I emphasise. And then 88, he refers to two arguments that were made on behalf of Mr Modi, which he rejects as being lawyers' constructs. And then 89, my lords, it's a rolled up conclusion where he says the above represents an overarching summary. And then finally he says, I do not consider that Quantum has proved that Mr Modi made material misrepresentations with the meanings it alleges, or that he intended or that the Margs understood such to be the meanings. Now, I'd just like to make a few points about the judge's findings in this respect. So first of all, if your lordships go back to 78, paragraph 78, notwithstanding, my lords, I've shown you the pleaded case, and notwithstanding that it was being alleged that there was a series of different representations, in fact, in the judgment at 78, the judge only makes a specific finding in relation to two oral representations concerning funding. So that's at the very bottom of paragraph 78 on page 95 of the bundle. I am not at all satisfied that he stated orally that Sheikh Nayan had committed 100 million and Dr. Shinawatra 60 million. Now, he didn't make any findings as to any other representations. We only see the rolled up conclusion, as I say, in paragraph 89. So there's nothing at all about any other oral representations. There's nothing about any written representations. He didn't make any findings, my lord, about what the statements meant if the claimant's case was not correct. So if he rejected the claimant's case, but he didn't make any findings about what the statements did mean. He also, my lords, I referred to this earlier, but he elided the issues of whether the representations were made and whether they could have been relied upon. And if I could just show you again two places where we say he's done this. At 85 and 86, he says, given Mr Modi's way of socialising dealing, it would have been wholly unrealistic to take it that everyone or anyone mentioned by him was already bound to participate. And then 86, Mr Modi seemed to me indeed predominantly aspirational, and however shrewd, inclined to the emotional as well as the grand, and not always very practical. Mr and Mrs Marg are confident, intelligent people. They were unlikely to be seriously misled. And then 87.
So just pausing there,
Yes, my lord.
you say the judge is eliding representation and reliance. As I
Yes.
understand it. And I follow that. These paragraphs might be thought to bear on representation, mightn't they? Because the judge is right that to succeed in your claim, you have to show that the Margs understood what was being represented in a particular sense. So these points, well, it would be wholly unrealistic. That might be thought to be something bearing on the likelihood of the Margs understanding what was being put forward in a particular way.
Yes, although that's certainly the way in which the judge thought referred to matters, because he does refer to whether or not Mr Modi intended things to be understood in a particular way, whether or not Mr and Mrs Marg understood them in that way. But my lords, ultimately the question, a combination of representations were pleaded, so the written representations and the oral representations. And what we don't see in the judgment is any finding of this is what, on my conclusion is that this is what was said. And in fact, my lord, if we then look at the next paragraph, the reason I say this is all a conflation of representation and reliance is because the next paragraph, which I was just about to take you to, is actually the best example of the point I'm making. Because in relation to the WhatsApp message, that the judge says it's consistent. So Mr Modi is writing in August, referring to Mr Anand as an Iron Care board member trustee. And he says, whilst that is consistent with Mr Modi having previously so misdescribed Mr Anand, Mr and Mrs Marg could certainly not have believed that Mr Anand was bound to participate once he was deceased. And my
So
lords,
that, you say, is clearly a reliance matter rather than a representation
exactly. And I respectfully submit that, in fact, the earlier paragraphs, that is also what is going on. That that there is no separation of, as I say, the issues. If one's looking at this in the abstract, what statements were made? Was there an intention to induce? Well, what statements were made? Were they fraudulent? Was there an intention to induce? Were they relied upon? There's no breakdown, my lord, of those separate issues. And so we do say, for that reason, my lord, that we say the judge didn't marshal the issues properly, nor did he give proper reasons in his first judgment. Paragraph 89 is, as I've described it, a rolled-up conclusion trying to cover all matters. And then we get to the supplemental judgment once the claimants have applied for permission to appeal. That's Core Bundle tab 8C. And again, I know your lordships will have looked at this, but paragraphs 5 to 12 are key for present purposes. At 5 to 7, the judge essentially says it is not incumbent on him to make a finding as to what the statements did in fact mean. So he says it's okay to reject the Marg's case as to what was said, but not to make a positive finding. That's 5 through to 7. And we say that's an error, and it was incumbent on the judge to make a positive finding. And you'll see, my lords, also at paragraph 11, I do not consider that it is necessary to explain what, as a positive alternative to Quantum's case, the IPD document or extracts of it meant or may have meant. And then we see paragraph 12, which is the judge's attempt to give an explicit conclusion as he describes it. I consider that the roll call of outside individuals identified in the IPD was no more than aspirational, like so many of Mr Modi's statements, a grandiose vision, which included a pool of many famous people whom he envisaged at one time as participating in due course. And then in 13, what matters more perhaps is that Mr and Mrs Marg did not prove that they understood and relied. But my lords, in relation to paragraph 12, he's seeking there to provide an explicit positive conclusion as to what was said. But we say that's also problematic because he's only there talking about the IPD. There's no reference to the leadership board and nothing in relation to the oral representations. And we say that this court has given guidance in the Symmetra case. And if I could just ask you to turn that up at tab 6 of the authorities bundle. At page 111 of the authorities bundle, paragraph 46 of the judgment. I'm sure your lordships are familiar with this, but if I could just highlight the third point that's made in paragraph 46. The best way to demonstrate the exercise of the necessary care is to make use of the building blocks of the reasoned judicial process by identifying the issues which need to be decided, marshalling, however briefly and without needing to recite every point, the evidence which bears on those issues, and giving reasons why the principally relevant evidence is either accepted or rejected as unreliable. And we respectfully submit that the judge failed to do that.
Don't we need to begin with the first line of paragraph 46? That this is expressly said to be not an attempt to be comprehensive or prescriptive.
Of course, my lord. Of course, every case where this sort of challenge is brought turns on its facts. I completely accept that.
But isn't in other contexts, it's often been said by this court that the lower decision maker is not sitting in exam paper. So that kind of dissection of a judgment may not necessarily be appropriate.
Well, my lord, I'd say two things in relation to this. The first is I'm about to come on to the more fundamental complaint that we make is actually in relation to the substance of the judge's conclusions,
yes,
which I'll come to. But just pausing here in relation to the failure to marshal the issues, your lordship is absolutely right. The courts often say succinctness as they do here. Succinctness is as desirable in a judgment as in counsel's submissions. But, my lord, there are cases which fall the wrong side of the line, and indeed Symmetra was one such case. And we do say, with respect to the judge, this was an egregious example of a failure to spell out and consider each of the alleged representations. I've shown your lordships the pleading for that reason. One doesn't see in either of his judgments, even when a complaint was made in relation to the application for permission from the judge, even when it was being said to him, you haven't spelt out your reasons, we still don't see in the supplementary judgment proper consideration we submit of each of the representations, and in relation to each of those representations, each of the legal issues that arises. Now, of course...
Does he need to split out, for example, the patron representations and the leadership representations and the brand ambassador representations? Admittedly, they're all separately pleaded, and you've shown us the documents. But his finding is that Mr. and Mrs. Marg did not understand, from what they were shown and told, that these people had committed. And that's his finding. Now, you may say that there wasn't the evidence available to support that, but if that was a supportable finding, does he need to say separately the patron representation wasn't made, the brand ambassador representation wasn't made, the
My lord, no.
leadership wasn't made? Can't he just deal with it in that comprehensive
He may be able to
fashion?
deal with that issue in a rolled up or combined way. But where we say he did err was in relation to the failure to look separately at the oral and the written representations, for example, because those do require, we submit, separate consideration. And we also submit on the law, it was incumbent on him to consider, as I say, to split out this question of whether the representation was made and whether they were made with the intention to induce and whether, in fact, they were relied upon. Those are, as we would respectfully submit, the basic elements to the deceit claim, and one doesn't see anywhere in the judgment separate consideration of those questions.
How far actually was it alleged that things had been said orally that went beyond what was in the documents?
Well, my lord, the easiest way to demonstrate that point is in relation to the funding representations, those were said to be oral.
And the judge there specifically rejects that?
Only in relation to 2 of the 5, I believe, funding representations. And so my lord, just picking that point up, so in paragraph 78, there are only actually 2 specific findings in relation to the funding representations, and indeed only 2 of the funding representations. So nothing in relation to the others, nothing in relation to the written representations. And we do say fundamentally that it was incumbent, as I say, we respectfully disagree with the judge's approach in the second judgment, where he says it wasn't necessary for him to spell out what these representations did mean, and we say that that was an error of approach. But I do stress that our more fundamental complaint is that on the substance the decision was an unreasonable one, and I'll come to that now. And your lordships obviously have 2 skeleton arguments from us, but what I am going to do on this issue is to try and boil the points down into 7 points as to why we say the conclusion that Mr Modi did not make the statements in the terms alleged was an unreasonable one. Now, the first point is as I've shown your lordships, the judge found that Mr Modi was confused as between vision and reality. That's paragraph 83 of the judgment, and we say that that's a very important finding because it makes it highly likely that Mr Modi would in fact have made the statements in the terms alleged. What the judge was essentially saying was that even where people had not in fact agreed to be involved in the Iron Care project, Mr Modi was prepared to say that they had in fact agreed. So he was confused as between what was reality and what was his vision. And one can see this point very clearly by looking at Mr Modi's oral evidence, the oral evidence that he gave before the judge in relation to Sheikh Nayan and Dr Thinawatra in particular, who, as your lordships have seen, were referred to in the investor pitch deck as co-chairs and trustees, and they were also depicted in the leadership board, and they were also, your lordships have seen, the subject of the oral funding representations, or 2 of them. So if I could just show you, if we go back to the judgment, just to see the references to those individuals in the judgment, and then I want to show your lordships some of the transcripts. at paragraph 75, the judge says in relation to Sheikh Naihan and Dr. Shinawatra, their case that they were misled into believing that Sheikh Naihan and others, including Dr. Shinawatra, had agreed to be appointed later is evidentially thin at the very least. At 78, the beginning of 78, whilst it's plausible that Mr. Modi did refer to Sheikh Naihan, Dr. Shinawatra, Mr. Brown, Mr. Anand during the meeting, and then we've already looked at the rest of 78. And then at 82, the judge says Mr. Modi probably did know and had approached most, if not all, of the 30 patrons and leaders. Now, we say that's actually wrong, and I'll come back to that point, but I'm just focusing now on Sheikh Naihan and Dr. Shinawatra. So they're referred to at 82. And then at 83, in his confused account of what was vision and what was reality, it emerges unlikely that they had definitively agreed. So that's the judge in his judgment dealing with the position of those two individuals. But with respect, we say that in fact the judge has made a demonstrable failure to consider relevant evidence in relation to these two individuals, because during his cross-examination, Mr. Modi stated that these two individuals had, in fact, actually agreed. Not merely that they were part of his vision, but they had actually agreed. And so I need to show your lordships the transcripts. And there are several references. If I could begin, it's the unagreed supplemental bundle. If I could ask you first to turn up, it's page 291 of the bundle, which is day 3 of the trial. And if we could pick this up at page 136 of the transcript, please, at line 4. I wonder if, in fact, I could ask your lordships to read from 136.4 through to 138, line 14, please. That may be easier.
Yeah, I'll do that.
So my lord's quite clearly saying that he had agreed. That's the bottom of page 136, the top of page 137, and then in answer to the judge's question on 138. And now if I could ask you to look at the next day of transcript, so behind the next tab, please, at 302 of the bundle. And this is effectively the next day, so the cross-examiner was picking up on the questions and answers given there. And if I could ask, again, your lordships to read to yourselves at page 6 of the transcript, line 5, through to, in fact, page 8 of the transcript, at line 10, if I could just ask you to.
Yes.
So the gist of the cross-examination here was, well, you never said previously that these individuals had in fact agreed. And he says, Mr Modi's answer is, well, I'd asked them and they never said no. And if I could then turn to page 10 of the transcript, which is just over the page, and perhaps again ask your lordships to look at line 7 to 19. Page 10 of the transcript.
Yes.
I'm grateful. And the next reference is page 17 of the transcript, if I can just stick with the transcript references. Page 17, at line 3, through to page 22, line 9. And I apologise for the length, but it is important.
So, sorry, that was 17 to 23.
17, line 3, through to 22, line 9.
22.
And you'll see the judge himself ask questions about this. So crucially, we rely upon and draw your lordship's attention to the fact that in answer to questions from the judge, page 19 of the transcript and pages 21 and 22, the judge is specifically asking whether Mr Modi's evidence is that by April 2018, this is the bottom of page 21, the Sheikh and Dr Shinawatra were not just part of the vision, they had actually become involved and had agreed that they would have leadership roles. And the answer given is correct.
Now, Ms Stilnot was obviously asking these questions with a view to establishing that they hadn't taken on those roles. Mm-hmm. And the judge found that they hadn't, in fact, taken on the roles. You, as I understand it, are seeking to deploy these answers to suggest that Mr Modi is the more likely to have said that they had taken on the roles because come trial he was inclined to say that they had.
Exactly, my lord.
But if the truth is, as the judge found, that they hadn't taken on the roles, does the fact that Mr Modi said at trial that they had bear much on whether he would have said at the earlier stage that they had?
My lord, we say yes, and we say what the judge describes in his judgment as a confusion between vision and reality is highly probative of whether Mr Modi would have made statements at the meeting in the terms alleged. Because if he is saying to the judge in response to a direct question, are you saying they had actually agreed? And he's saying yes, then we say that does bear upon the question. If the judge's job, as it were, was to make findings as to what was likely as to what Mr Modi would have said. Would he have said to these individuals, to Mr and Mrs Marg, that these individuals had actually agreed, or was it merely forward-looking that he hoped to get them involved? Now, if Mr Modi is saying, when cross-examined, that they had in fact agreed, we do say that's highly relevant evidence. And one doesn't see any reference or proper consideration of that. We just see a reference to a confusion between vision and reality. Now, we say the judge was absolutely right to dismiss this explanation that the Sheikh and Dr Shinawatra had agreed, because simply not responding is not agreement. So we say the judge was right in that respect, but crucially, my lords, we do say that this sort of evidence makes it highly likely that Mr Modi would have made the same sorts of statements in the meeting when he was actually looking to persuade Mr and Mrs Marg to invest.
But don't we have to read the evidence as a whole? And we obviously haven't. We're being taken to parts of it, but even in the parts you've taken us to, certainly the earlier answers the defendant was giving in evidence, correct me if I'm wrong, Mr Singler, but they seemed to be along the lines of, well, they hadn't said no. And when people disagree with me, they tell me clearly and straight away. So it's a very, at least to my mind, it's not a clear statement that he's saying, oh, they definitely had agreed.
Well, my lord, you're absolutely right. Mr Modi's evidence was, first of all, we saw that on day 3, that he said categorically they had agreed.
Yes.
And then when asked about this on day 4, his position was, well, I asked them, but they never said no. So that does give rise to 2 separate questions. One, had they in fact agreed? And the judge dismisses that, and we say rightly so.
Right.
But the ultimate question for the judge, and we submit your lordships, is it likely that Mr Modi would have said to the Margs that these individuals had in fact agreed? Now, if Mr Modi was so confused, as the judge described it, when giving oral evidence, we do say, as I said in response to Lord Justice Newey's question, that when weighing up the probabilities, if he's prepared to say in oral evidence that so far as he was concerned they had agreed, then we submit that that is highly relevant when considering whether he would have said that in the context to Mr and Mrs Marg.
Yes.
And if I show you another piece of evidence that he gave in relation to another individual, again, to bring out this, what the judge in passing describes as a confusion between vision and reality, but we say that's actually fairly fundamental in terms of what your lordship, what his lordship was having to decide. If one looks at day 4, page 177 of the transcript, if you still have that open, it's 345 of the bundle. And this is in relation to Mr Salve, which is why I pointed out his references in the IPD and the Leadership Board. And if I could ask your lordships to look at page 177, line 10, through to 178, line 1.
Yeah.
Now we know, because the Margs wrote to him and he responded, and this is all set out in paragraph 77 of the judgment, that as a matter of fact Mr Salve had not agreed to be involved. So that's clear. But again, with respect, we say the fact that Mr Modi would say in oral evidence that he's my advisor, I hadn't asked him but he was retained by me, we say that makes it highly likely that he would have said exactly the same thing at the meeting with the Margs. And again, one doesn't see any proper consideration of the fact that Mr Modi was giving this oral evidence. And a crucial further piece of evidence, which we say is completely overlooked by the judge, at day 4, page 156, and I do appreciate Lord Justice Singh's comment that I'm taking you to pieces of evidence, but of course in an appeal of this nature, one has to... But in relation to this point, the judge doesn't deal with this at all. Day 4, page 156, line 12 through to page 157, line 16, please.
We'll read those.
Thank you. And the key bits of evidence here, page 157, he is confirming, Mr Modi, that he would not have given the qualification in relation to these individuals that they were merely part of his vision. He says that in terms on 157. So, my lords, he may have referred to this repeatedly in his oral evidence as the investor pitch deck as his vision document. There are many places in the transcripts where he refers to the IPD as his vision document. But his oral evidence was that he wouldn't have given the qualification to Mr and Mrs Marg. In other words, he wouldn't have said these were people who he wished would join the business in the future. He would have said they were part of the business already.
Well, lines 10 to 13, what do you say about that? He seems to be saying that the opposite there. I wouldn't have said XYZ is a patron, XYZ is a brand ambassador, or XY I know for a fact. And earlier he says at line 10, I was talking about my vision. So, I mean, at best it might be said it's all very confused.
Well, my lord, the fact that it's all very confused is a point that we rely upon.
Right.
Because his confusion, even when giving oral evidence, and even when asked direct questions from the judge, as your lordships have seen, we do rely upon that, and we say that's a point in our favour. Because if he was so confused as between vision and reality, then we say that increases significantly the likelihood that he would have said, when actually looking to raise money for the business, that these individuals are in fact signed up. They have agreed to be involved.
Can I try spinning it differently? Take the IPD, where we see these people. So we know what, as a matter of words, was being said. But then you have to ask the further question, how did Mr Modi intend those words to be understood by the Margs? Might it be said, well, if he's so confused about reality and vision, you can't infer that he meant those words to be understood by the Margs as these people have already signed up?
Well, all of the evidence needs to be looked at in the round. I mean, the question of what Mr Modi intended the recipient of the statement to understand is one factor, but ultimately the question is looking at objectively, what does the evidence tell us? And we say that, I'll come on to this in relation to some of my other points, but when one looks at the context of this meeting, which was essentially a pitch by reference to a document called an investor pitch deck in relation to a company which we know was incurring significant debt. So all of that context I'll come back to. But in that context, we've seen the IPD, we've seen, for example, the reference to Dr. Shinawatra as is the chairman. And your lordship's absolutely right, there is a further question as to what did he intend to convey. And Lord Justice Singh is also right that some of this evidence is incredibly confused. But we say, putting that all together, that weighs significantly in our favour. And what one is not seeing in the judgment is any proper consideration of these matters. And I'll come on to my next point of the 7, the second point, because what the judge says is, in the supplemental judgment, he rejects the case of Mr Modi that he was merely giving illustrative details, but he does go on to accept the case that he was giving his future vision. That's the supplemental judgment, paragraphs 11 and 12. And we say that is a logical inconsistency. We say there are 3 problems with that reasoning by the judge. The first, my lords, as I've already mentioned, is that Mr Modi did not, in fact, give 2 different explanations. Can I perhaps just show you the reference in the supplemental judgment so that you have in mind paragraphs 11 and 12. So in 11, he says, Mr Modi's evidence was that the IPD represented his vision and that the individuals mentioned in the IPD were merely illustrative. Whilst I was not that impressed by the way he expressed the latter, the former characterization was consistent with other evidence. So that's the way in which, that's where the judge ultimately lands in his second judgment. But as I've shown you, in his defence, his witness statement and his oral evidence, Mr Modi was only ever giving a single version of events, namely that he definitely didn't say these people had agreed. He was only ever, at most, giving his vision as to the future. Now, we saw some references in the defence to the phrase illustrative details. I think there's nothing in the witness statement about illustrative details, but in the defence, and there's nothing in the oral evidence, one searches the oral evidence for illustrative details, one doesn't see any reference by Mr Modi in his oral evidence to that phrase. But the references in the defence to illustrative details are clearly part of an overarching and single explanation that all he was ever doing was setting out his vision. So this, we say, was an entirely artificial distinction created by the judge himself. So we say that there's a problem there. Secondly, what the judge doesn't grapple with is the fact that sometimes Mr Modi, it's clear, was using not a future tense, but the past or the present tense. So I've shown you the reference to Dr Shinawatra in the IPD. He is the chairman, and we rhetorically ask the question, how on earth could that be a vision or a forward-looking statement? He is the chairman. And what one also sees in paragraph 78 of the first judgment, the judge says, it is not impossible that Mr Modi said that Sheikh Nayan and or Mr Brown, among others, had assigned land in their countries for use as possible treatment centres. So it's not impossible that he would have said that. But of course, those are statements in the past tense. So our second point as to the substance of the judge's conclusion is that it wasn't open to him to distinguish between illustrative details and vision. And indeed, there was evidence that Mr Modi used the past or present tense and could not have been explaining to the Margs that this was just his vision. And then my third point, my lords, is the treatment of the Kofi Annan message. And just so that your lordships can see the message itself, that's in the agreed supplemental bundle, behind tab 9 at page 124. And just by the first hole punch, your lordships will see on the 31st of August, Iron Care board member trustee, Kofi Annan funeral in Accra on the 13th. And so there's no qualification there. There's no vision, there's no proposed or intended. We say that is an absolutely clear statement that Kofi Annan was an Iron Care board member trustee. And we also draw attention to the fact that the judge himself asked Mr Modi about this message. And let me show you that. If I could ask you again to turn up the transcripts. On day 4, which is behind tab 4. I think it's page 336 of the bundle. And could I ask your lordships to look at page 141, line 13, through to 144, line 22, please.
So through to 144,
line 22, please. So, my lords, the judge himself was asking Mr Modi about these about the message. He was asking questions about the reference to Iron Care board member trustee. And then we come to look at how this was dealt with in the judgment. Because we say this is a very good example of the unreasonable approach which the judge took to the evidence. At 87, so he refers to this, he says, a striking reference by their counsel at trial. And then he says it's consistent with Mr Modi having previously so misdescribed Mr Annan. So just pausing there, we know Kofi Annan was referred to in the IPD. We know he was referred to in the leadership board. The judge himself is now saying the message that he sends in August is consistent with Mr Modi having described Mr Annan in that way at the meeting. But the problem is the judge doesn't separate out the questions of what was represented and what was relied upon. And we say this is wholly unreasonable because the judge then goes on to turn this point around and say, well, Mr and Mrs Marg could not have believed that Mr Annan was bound to participate once he was deceased. Now, my lords, with respect, that's just missing the central point. That the importance of the WhatsApp message is because it bears upon the question of what Mr Modi is, what he's likely to have said at the meeting. And the judge dismisses that as a reliance point. He says, well, beyond August 2018, they can't seriously have believed Mr Annan was involved. And we say with respect, that is an unreasonable treatment of the evidence. Now, the fourth point I'd like to make is...
Sorry, you're on your master list of 7 points.
7 points, yes.
Just before you leave paragraphs 11 and 12, I mean, this is maybe a point for Mr Mill, really. So the judge says that the roll call was aspirational in paragraph 12. A vision of people who he envisaged as participating. I'm not quite sure how that differs from saying that it's illustrative.
Well, my lord, you have my submission on this. Mr Modi was only ever giving one version of events, which was this was all forward-looking. Now, whether you describe that, it's illustrative, a vision, forward-looking, proposed, it's 1 point.
And I quite followed how you put it in terms of what Mr Modi's case was, but here the judge seems to be drawing some distinction. And I put down a marker now for Mr Mill. I'm not quite sure that I understand the distinction.
I'm grateful. I mean, we pray and aid that the fact that the judge has created this distinction out of nowhere, which we say is incoherent. Now, the fourth point on the master list is relates to paragraph 62 of the judgment. So this is the boasts and puffs paragraph. So at the end of paragraph 62, the final sentence, as an aside, I may add that neither Mr nor Mrs Marg seemed to me at all gullible, and despite Mr Modi's past achievements and connections, I would expect them to have taken some of his possible boasts and puffs, as I did, with at least a pinch of salt. And then to similar effect, I think I've already shown you 85 and 86. It would have been wholly unrealistic to take that everyone was bound to participate. He seemed predominantly aspirational, one sees that word again in 86. And they're confident, intelligent people. They were unlikely to be seriously misled. Now, in relation to the boasts and puffs point, again, can I just show you this? Because that was never pleaded or run by Mr Modi or on behalf of Mr Modi. It was never said, well, he did say these things, but they were merely boasts and puffs. The way in which this boasts and puffs point emerged, if I could just show you, there's an extract from the oral closing submissions. If I could ask you to turn up the transcripts bundle, so day 6, which is tab 6. and the relevant passage is on page 28 of the transcript, at 359 of the bundle. Your Lordships will see the judge asks counsel for the claimants, line 21. But this is more fundamental. This is the difference between specific statements of fact.
Sorry, I haven't kept up with you.
I'm sorry, my lord. It's line 21 on page 28 of the transcript.
Yes, I see.
And I'll just let your lordship look at the question from the judge. So, my lords, this point was never, as I say, pleaded or argued on behalf of Mr Modi. The judge himself, in the middle of the claimant's closing, says this is a big issue in this case. Now, my lords, we say two things in relation to that. The first is it's wrong because specific statements of fact. So if the claimant's case is correct and the statements were these people have already agreed to participate, that wouldn't in fact be a boast or a puff in any event. But more fundamentally, and with respect to the judge, the reasoning here, again, is logically incoherent. As with the Kofi Annan message, where he says it's consistent with how Mr Annan might have previously been described by Mr Modi, likewise, this comment about boasts and puffs only makes sense if the judge has in mind that Mr Modi did in fact say that these individuals had already been signed up. Because if the statement was merely, I intend in the future to ask these people to take on particular roles within Iron Care, then there's no question of Mr and Mrs Marg being gullible or needing to take that sort of statement with a pinch of salt. So again, we say there is a problem, an error in the judgment, insofar as he seems in some places to accept that the statements were made, and then in other places, and your lordships know his ultimate conclusion is that none of the representations were made out.
Can I just try spinning that differently again? So take the IPD, where we know what the words were. One question is what Mr Modi intended the words to mean. Another is how the Margs understood the words. Suppose their perception was that Mr Modi is the sort of person who makes grandiose statements. Might that bear on how they understand the words on the page?
But my lord, the difficulty with respect is that the question is what statement was made. And we say that the question of whether Mr and Mrs Marg were gullible, that only arises, one first has to establish on the evidence what statement was made. And we say there can't be any question of a statement that I intend to ask these people in the future. We say that's not the boast or puff point just doesn't arise, or them being gullible doesn't arise in that case.
Is that right? Your pleaded case, I know it wasn't you personally, but the pleaded case for the claimants was that there were written representations by showing the slides. The judge didn't actually find that there were slides, but the IPD effectively consists of a pack of slides. And as I understood the way Miss Dilnott was answering the judge in the passage you were shown us, she's saying, look at the words on the page. Now, there is no room for dispute about what the words on the page say. So in that sense, it's not like an oral representation where you first have to establish what was said. You can see what was said, but there do still remain the two questions my lord has put forward. What did Mr Modi intend that to be understood as conveying? Because you can only convict someone of fraud if they intended it to be understood in a particular sense and knew that that sense was false. And how was it in fact understood by the recipient? Because you can only... And I don't think this is quite a reliance point. I think it's a question of how the statement was received at the time. Reliance is whether you acted on it later, but you first have to show that the Margs did understand it to be a statement as to who was currently on the board and had agreed to be patrons.
Yes.
So those two questions do have to be answered, and the judge does answer them adversely to the claimants.
Yes. Then,
and that's not a question of what were the words on the page, because my lord says we can see the words on the page. It's a question of, in the context of that meeting, what did Mr. Modi really mean when he put this forward, this document, and how did the Margs really understand it?
so I'm just my next point is in fact around the nature and the context of the meeting, which we directly relates to this question of what was he intending and what was the recipient understanding them to mean, the context and the nature of the meeting. But just on the boasts and the puffs issue, we say the judge has made a finding essentially that there were boasts and puffs. He says that they needed to have taken them with a pinch of salt, as I did. So he's made or has in mind that boasts and puffs were made by Mr. Modi. And the rhetorical question that I'm posing is, well, if you're describing something as a boast and puff, what is it? What statement is it that you're describing as a boast or a puff? And in my submission, he can only have had in mind in that paragraph of the judgment that this statement was in fact made in the terms alleged, but it was a boast and puff and should have been understood with a pinch of salt. And that's the logical problem we submit with the judgment. And as I say, it's similar to the treatment of the Kofi Annan message, where he says it's consistent with Mr. Annan having been described in that way. There are places in the judgment where the judge does seem to accept that a statement was made in the terms alleged, but then ultimately concludes, in fact, none of the representations were made out. It just simply, we say, is illogical to describe something as a boast or a puff if the statement was, I intend in the future to approach these people. We say the judge must have had in mind that the statement was made, these people are signed up. And the judge says, well, that was a boast or a puff, and you shouldn't have believed him.
Well, the statement is actually made, take the leadership board, the brand ambassadors. The statement is actually made as brand ambassadors, here's some famous people. Now, you can say that, and this was your case, that by putting those pictures from the cover of magazines under the heading brand ambassadors, what Mr. Modi meant the Margs to understand, and what they did understand, was that these people had already agreed to be brand ambassadors. What the judge, I think, finds is when Mr. Modi describes these people as brand ambassadors, he's not really saying, nor was he understood to be saying, these people have agreed to be brand ambassadors, but this is what it's going to look like, and these people are going to be brand ambassadors for the company or the foundation. And the judge is really saying that's how it's understood, and I don't think it was understood as being a statement of present fact at all.
That is ultimately where he ends up.
Yes,
but
what's wrong with describing that as a boast or a puff?
Well,
I mean, I don't, with respect, I don't see that there's anything inconsistent in the judge saying, Mr. Modi's putting forward these people as brand ambassadors, but they're not really, and they weren't really understood to be. These people have signed on the dotted line, and I've already got them agreed. Wasn't what Mr. Modi meant. It wasn't what the Margs understood. But it could still be described as a boast. But look at all the famous people I know. They're going to come on board.
Well, let me come to the next point, which is the nature and the context of the meeting. But
just so I keep my...
It's the fifth point, is that...
Yes.
But just before I develop that, the first problem, to Lord Justice Nugee's question, the first problem with that analysis is that we've seen in the investor pitch deck at least one reference to Dr. Shinawatra being the chairman, present tense. And so on any view, we say that that was a written statement of present fact, and there's just no way around that. But secondly, my lord, we do say that if the statement was merely, well, here's a bunch of people I know or intend to approach in the future, then it doesn't really arise to say, well, that's a mere boast or a puff, and you should have taken that sort of statement with a pinch of salt, because that sort of statement would simply not have been, it wouldn't have been the actionable statement that was alleged. What he actually has in mind, we submit, is that when he's saying you should take it with a pinch of salt, you're not gullible people, he must have in mind a stronger statement than simply, I intend to approach these people in the future. But I think the real point emerges with my fifth point, which is when one actually thinks about the context of this meeting, is it more likely that he was saying these people had been signed up, or merely that he was saying, I intend to approach them in the future? And we say the judge's conclusion is unreasonable when one considers the nature and the context of the meeting. Now, in relation to this, the judge, you will have seen, refers in 3 places in the judgment to the meeting being a first preliminary meeting. That's paragraphs 78, 81 and 94. I don't think we need to turn that up. And in the supplemental judgment, paragraph 10, the judge emphasises the late night informal setting between people who knew each other socially after a chance meeting. Now, we say that in fact, looking at the evidence in the round, the nature and the context of the meeting makes it very likely that the statements were made in the terms alleged. So to develop that point, we know that by April 2018, Mr Modi had been trying to launch this business for 2 years without any real success. And indeed, this is recorded, it's briefly alluded to in the judgment. If I just show you paragraph 54. Which is page 90 of the core bundle. By the time Mr Modi introduced Ironcare to Mr and Mrs Mark, he'd been trying to launch it for approximately 2 years, had in use various investment proposal documents to seek the extensive funding needed, but seems only to have obtained advances from Ellington and Mr Jaipuria. In the meantime, Ironcare had already incurred large debts and ongoing contractual obligations required for collaboration with CCU and its personnel. And we know, my lords, that by December 2018, Ironcare needed to pay $5 million to the Antiguan government. And if I just perhaps give you the references in this respect, Mr Modi confirmed this at day 4 of the transcript, page 47, lines 7 to 18.
Sorry.
Oh, I'm sorry.
Page 47.
Lines 7 to 18.
Yeah.
And he also confirmed in his oral evidence that he didn't tell the Margs this, which is page 51, lines 1 to 8. And so what we know is that the government of Antigua and Ironcare had signed a memorandum of understanding, and there was a $5 million debt that was owed by December 2018. And as the judge refers to, there were also already large debts incurred in relation to CCU. So just pausing there, the background to this meeting clearly indicates that Mr Modi had a motive to deceive the Margs. There's a clear purpose to this meeting, which is to induce investment. And if that was the purpose of the meeting, then it obviously wouldn't have been sufficient for Mr Modi simply to have outlined his vision or his intentions for the future. The only way to attract investment is to say these people have already signed up. And we submit that the judge has failed properly to take into account the commercial reality and context of this meeting. So the context is the company's incurring large debts. It hasn't got off the ground in 2 years. He then produces a document called the Investor Pitch Deck. And we say it would have made no sense at all to put names and biographies of individuals into the Investor Pitch Deck and the Leadership Board unless he was seeking to give the impression that they had already committed. And so, to answer Lord Justice Nugee's question, we say when one looks at the context of all of this, and this is the problem that the judge doesn't deal anywhere with the question of intention to induce. That's just simply not the subject of any findings at all. But we say the context of this meeting is that he was looking to raise money for a failing business, and that makes it highly likely. Indeed, as a matter of commercial reality, he must have been saying, we submit, that these people had signed up. That would be the only way to attract investment. And the judge finds that this was a preliminary meeting and uses against the claimant's case the fact that this was a preliminary meeting between people that knew each other socially. But with respect to the fact that these individuals knew each other already is again a point which weighs in favour of these statements having been made in the terms alleged. Because Mr Modi would have known about Mrs Marg's successful track record as a venture capitalist investor, and likewise Mrs Marg would have known that Mr Modi had a successful record in terms of developing the IPL Cricket League and was also very well connected. We know, because the judge records this at paragraph 12, that Mr Modi instigated the meeting. We also know the meeting lasted approximately 3 hours. And we submit that all of the evidence was pointing in the direction of Mr Modi making these statements to induce Mrs Marg to participate in the Friends and Family investment round. And if I could just show you on this point some references to the oral evidence that was given at day 4 of the transcripts. At page 72 on 318 of the bundle, Mr Modi confirmed in his oral evidence at lines 3 to 5, page 72 of the transcript, you use Friends and Family rounds as a technique to draw investors in, don't you, Mr Modi? It would seem so. And at page 110 of the transcript, line 19 through to page 111, line 11.
Should we just read those?
Yes, yes, please, my lord. So Mr Modi was accepting that the Margs were talking to him because they were impressed by his venture and knew he could raise money. So with all of that context as regards the meeting, we say two things. First of all, the judge was wrong to use the fact that this was a preliminary meeting or there was a social connection between the individuals. He was wrong to use that against the claimants. In fact, that was a point in their favour, much more likely that he was trying to raise money from them by way of a Friends and Family first round. But secondly, we do, with respect, submit that this is the answer to the question Lord Justice Nugee is posing. What is he intending, and what are they understanding? If one now, having heard about that context of the meeting, thinks about the IPD, we respectfully submit that what is clearly happening is Mr Modi is making a pitch. My lords, the next point, the sixth point, is that there was evidence which emerged during the trial that Mr Modi had made other fraudulent statements, both to Mr and Mrs Marg and also to other individuals. And we submit that the fact that these other statements were made in relation to similar matters, I'll show you, but we say the fact that these statements were made it inherently likely that, again, he would have made the statements at the April meeting in the terms alleged. And I'll come on to explain the two points here, but one doesn't see any reference to either of these matters in the judgment. And in paragraph 46 of the Symmetra judgment, I won't go back to it, but the fourth point, I showed your lordships the third point. The fourth point is that judges are required as a matter of fairness to deal with apparently compelling evidence contrary to the conclusion which he intends to reach and explain why he's not accepting it. And we say these two matters fall into the category of compelling evidence contrary to the conclusion which the judge reached. So the first issue here, my lords, is that immediately after the meeting on the 13th of April, Mr Modi sent a message via WhatsApp to Mrs Marg in which he claimed that in relation to another business, a mixed martial arts league he was setting up, he said, I've sold 11 teams for 50 million each already. And I can show you the messages. If you could turn up the agreed supplemental bundle at page 82. So this is within 24 hours of the meeting with which these proceedings are concerned. In fact, if one starts at page 81 of the bundle, please. By the first hole punch, you can see Mr Modi joins the conversation, and then one can see a series of videos that are being sent by him. You can see in italics the attachments. So this is Mr Modi sending a series of videos via WhatsApp, and that continues over the page. And then on page 83, one can see 3 photos. Well, you can also see Mrs Marg saying, thank you for showing all the videos. And then there are 3 photos from Mr Modi. Now, some of those videos and photos related to Iron Care, but others related to Honour, which was this mixed martial arts league, and that's common ground. Mr Modi admitted as much, just for your lordship's note. He admitted that at day 4, page 108, lines 15 to 20. I don't believe all of those materials are in the bundles, but that's common ground. And then Mr Modi says halfway down, on page 83, so this is the 14th of April, so in fact the same day as the meeting concludes, he says, forgot about this, right up your alley. And the reason he's saying right up your alley is because he knew that Mrs Marg had previously invested in something called the One Championship in Singapore, which was also a martial arts sports league. And again, that is all common ground. It's Mrs Marg's first witness statement, paragraphs 12 to 13. And I think Mr Modi admitted it at page 108, line 21, to page 109, line 4. And that's also why your lordships will see later in the exchange, Mrs Marg says, I like the fact that we're in the same space. So he's saying, here are some videos or photos of this mixed martial arts league, and right up your alley, forgot about this. And then he says, sold 11 teams for 50 million each already. And you'll then see various messages. Miss Marg says, oh, awesome, I thought you'd written this off. Insane, fabulous. And Mr Marg over the page, halfway down, says, brilliant, lallet. So he sends numerous messages in which he's trying to portray this martial arts league as being a very successful business venture. As I say, the same day as the meeting with which we're concerned. And then we get his oral evidence about this. If I could ask you to look now at day 3. The relevant passage is page 109 of the transcript, 285 of the bundle. And could I ask your lordships to look at 109 line 21. In fact, 109 line 6 might be the right place to start. 109 line 6 through to 110 line 2, please.
I'll do that.
So in fact, this business venture hadn't gone anywhere. And if I could also show you day 4 at page 109. And if I could ask you to pick that up at 109 line 5, please. Well, in fact, again, just to put this in context, if I could ask your lordships to begin at 108 line 15 to see the first question. And then could I ask you to read all the way through to 112 line 19, please.
Yeah.
So, my lords, you've seen the message and you've seen the oral evidence which made clear that the statement was actually false. It was obviously a statement that he would have known was false. You've seen the judge himself asking and confirming the position. Now, we submit that that was very significant evidence. On the same day as the meeting in the hotel suite concluded, Mr. Modi was making another statement about another business venture, which he ultimately accepted in oral evidence was knowingly false. And we again rely upon that because we say that makes it more likely, highly likely indeed, that in relation to Iron Care he would have said statements in the terms alleged. And, my lords, the judge failed to consider any of this evidence at all. So the issue about honour, or the Martial Arts League, is not even mentioned in the first judgment. And if I just show you...
I'm sorry, where does he accept that it was knowingly false?
He doesn't accept it's knowingly false in terms, but it must have been knowingly false, we say, because it was his own business venture.
Well, again, and again, correct me if I'm reading things out of context, because that's always the danger with this. But at page 110 of the transcript, at line 8, he says people had already committed, but I hadn't agreed to any one of them. I mean, could it be said that this man is just completely confused in his evidence?
Well, possibly, my lord, but the statement in question here is that he's sold 11 teams for 50 million each already. So confusion doesn't help on this point, we say. I mean, that's just a statement which is obviously false.
You may be right about that, Mr. Singler, but it may go to questions like what he intended.
Well, my lord, we say that the effect of this oral evidence was that he did accept that he had not sold 11 teams for 50... Just taking this in stages, the statement was he's sold 11 teams for 50 million each. We say it's clear from this passage that he hadn't, in fact, at the time he sent the message, sold 11 teams. We then say it must be the case. I mean, this is not, to be clear, this is not a pleaded representation with which these proceedings are concerned.
No.
I'm just relying upon it. We say
I understand.
if the position was that he had, in fact, not sold 11 teams, we say he must have known that that was the position.
I see.
And we then say, so we rely upon this for two reasons. One, we say it's highly likely, in circumstances where he was saying this, making a false statement on another business venture to Mrs. Marg, we say that increases overwhelmingly the likelihood that he would have been saying the things that we allege in relation to Iron Care. But also, we rely upon this because the judge fails to deal with it. let me show you. There's nothing at all about this in the first judgment, and this is notwithstanding that the judge himself is getting involved in the question. So
is he obliged to do? I mean, this is not evidence on any of the issues in the case. It purely goes to credit. It goes to whether. Well, I suppose you might say it was similar fact evidence.
It's a bit more than credit, my lord, because it's the same individuals, the same day, in relation to another business venture. So it's
similar fact evidence.
Yes,
it's propensity to tell lies. That sort of
exactly
thing.
Exactly.
But it's not actually one of the issues that the judge has to decide, because it's not one of the pleaded issues. It's not actually directly relevant to issues in the case. So, to what extent does a judge have to spell out in a judgment all the various points which are urged on him or her by counsel? I'm not sure that a judge does need to
my lord,
deal with all those points.
I completely accept it's a question of degree, but we do rely upon, as I say, the reference and symmetry. So, in fact, it's a basic principle of fairness. One doesn't need to particular authority for it, but we say that where there's a compelling piece of evidence that weighs against the ultimate conclusion which the judge reaches, the judge is obliged to deal with that. And we say, of course, it's a question of degree, my lord, but on these facts, with this particular subject matter, I'll come to another one in a moment, but on this particular subject matter, whilst it's true the Martial Arts League was not the subject of a pleaded representation, we are talking about a message sent by the same person to the same person on the same day as the meeting concludes in relation to another business venture. So, of course, judges are not...
and the explanation that Mr Modi gives is that when he said sold, he didn't mean there'd actually been a signed agreement, but people he'd offered to the market these teams at 50, and he'd had plenty of offers, and he had in his own mind notionally allocated them, one of them Dubai, one of them Bombay, one of them Delhi, and so on. It's just it never actually was followed up with legally binding documentation, but in his own mind he's already got people to say they'll take them. Now, that may well shed some light on the judge's comment that Mr Modi found it difficult to distinguish reality from vision. To that extent, it may be quite a close parallel with what the judge found was going on in the meeting with the Margs. He says things, they don't mean I have signed a contract. They mean, in my mind, I've got someone who'll take this team.
But my lord, that's precisely the point as to why the judge ought to have considered this evidence, because it is a close parallel. If the judge ultimately concludes he reached the same answer in relation to this other representation or this other subject matter, then that may well be the case. But we say that the reason he was obliged to deal with it was because it was a close parallel, because Mr Modi's explanation was strikingly similar. He said he'd sold, in fact he hadn't, and at best there was confusion. So given the judge has made a finding about confusion between vision and reality in relation to iron care, the judge, we say, was obliged to consider this. And we say it's actually worse than the judge failing to consider this piece of evidence, because, as I say, there's nothing in the first judgment. But then if we look at the second judgment, core bundle, page 112, right at the top in paragraph 9, in parentheses, the judge refers to the fact that Mr Modi boasted orally about having raised huge sums of money for another of his business ventures called Honour, when in fact he had not. Now, the problem with that, with respect to the judge, is that this was not an oral statement. Your lordships have seen the message. You've seen that Mr Modi was cross-examined on the WhatsApp message, and there were in fact a series of messages after the initial one. So the judge has made a passing reference to it, which we say is inadequate, but even that passing reference is erroneous. And to answer Lord Justice Nugee's question, of course these things are not all pleaded issues in and of themselves, but if one looks, for example, at paragraph 10, just because we have it open, the judge is referring there to other circumstances around the IPD being illuminating. Now, we say that it was incumbent on him to take into account the martial arts point as part of the overall context. It's all part of the circumstances. He's sending a message to the same person on the same day. So My lords, that was the first example that we give of some important evidence that was just not properly considered, and if it had been properly considered, would have weighed in favour of the likelihood that Mr Modi had made statements about iron care in the terms alleged. The second matter in this respect is, again, to adopt the phrase, a close parallel. It's a different point. What happened here was that during Mr Modi's oral evidence, he accepted that an investor presentation in relation to iron care, so it's the same business, an investor presentation in 2017 contained statements which were false. And we don't, unfortunately, have the presentation in the bundle, so I'll just have to show you this through the transcripts. But first of all, you can see a passing reference to the document in question in the judgment. If you look at the first judgment at paragraph 47, your lordships will see about 2/3 of the way down, from at least April 2017 investment proposal documents referred to Iron Care's medical leadership and management teams and supervisory and executive boards, which included Sheikh Nayan and Dr. Shinawatra. So two of the key individuals that this claim is concerned with. So that's the reference to the document. And then I'll have to pick this up in the transcripts. If we could begin at day 4. At page 58, which is 315 of the bundle. And at lines 5 to 19 on page 58, if you just if I could ask you to read those lines, you'll see reference to the document that I'm referring to. So the document's April 2017, and it's in the form of a PowerPoint presentation, and it's entitled Memorandum of Terms for Initial Investment in Iron Care. And then if we look at page 62, lines 9 to 14,
Sorry, 9 to 14.
yes, that's quoting from the document. I'm sorry, it's unsatisfactory, my lord, I do apologise, but
Yes,
the statement is Iron has entered into a partnership with the CCU, and in fact the agreement wasn't reached until June 2017, and that's actually recorded in the judgment at paragraphs 11 and 48. So we know that as at April 2017, the binding heads of terms had not been entered into. And at page 63 of the transcript, lines 1 to 6, Mr Modi says, well, if it wasn't signed with the CCU, then yes, the presentation in April would be wrong. And then, if we look at page 66 of the transcript, still the cross-examination about the same document, and the question begins at line 13 at page 66, and perhaps I could just ask you to read page 66 through to 67, line 4, please.
Yeah.
So, my lords, this document in April 2017 was not only wrong about the binding heads of terms with the CCU, but more importantly or relevantly to the present matter, there was a statement that Dr. Shinawatra was responsible for international business development. And Mr Modi says if it did go out to investors, it would be wrong. In fact, the evidence at trial was that it did go out to investors. And we say, again, two things about this. One, significantly increases the likelihood that he would have been saying in April 2018 to the Margs, Sheikh Nayan and Dr Shinawatra are signed up. And secondly, none of this evidence is referred to in either judgment, notwithstanding that it is a very close parallel. So, my lords, that was the sixth point. And the seventh point is that on any view, there are two clear errors on the face of the judgment where we say the judge has said certain things which are plainly wrong when one looks at the transcripts and one can see what the oral evidence was. So let me take the first point, which if we started with the judgment at paragraph 82. The aspect of paragraph 82 which we criticise is the reference to Mr Modi probably did know and had approached for iron care most, if not all, of the 30 patrons and leaders to whom he may have referred at the meeting, including Sheikh Nayan, Dr Shinawatra, Mr Brown and Mr Annan. He even knew some of the brand ambassadors identified in the last third of the leadership board, such as Messrs Federer and Ronaldo. Now, when one looks at the oral evidence given by Mr Modi, that's just simply wrong. So if I could again take you back to the transcripts. Day 4, please, at page 140. So 140, line 9. The judge says, but you knew all these people, didn't you? Either directly or through some other people, yes. Yes, correct. And then the claimant's counsel, in which case you didn't know the King and Queen of Spain? No. You didn't know Princess Haya? No, I didn't. You didn't know Sheikh Mansour bin Zayed? No, I didn't. You did know Prince Andrew, is that right? Yes, I do. And you told Mr and Mr Malik, who's a dear friend with whom you commonly interacted, I commonly meet with him. And Kofi Annan, is he a friend of you also? Do you just know his son? I know his son very well, I've met with him. So you're saying you met with him, but you weren't a friend? I'm a friend of his son's, I know, that's why I'm asking, you weren't a friend of Kofi Annan's? No. So, with respect, very difficult to see how the judge has concluded what he has in such broad terms in the light of that evidence. And in relation to Roger Federer and Cristiano Ronaldo, I showed you earlier references at paragraph 28 to those individuals in Mr Modi's witness statement. He never suggested in his written evidence that he knew those individuals, and there's nothing in the oral evidence where he says something to that effect either. So on any view, the finding in paragraph 82 we say is wrong and fails to take into account relevant evidence. And it's also wrong insofar as the judge says Mr Modi had approached all of those individuals. Again, just to pick up perhaps two references on this point. Day 4, page 163. Line 25. A question is asked about Gaston Brown, the Prime Minister of Antigua. And you'll see the question at line 4 on the next page, 164. You don't claim in your evidence that he had been or had agreed to be involved. I said he was part of my vision. So your answer is he'd never agreed to be involved. I hadn't approached him. And yet your lordships have seen what the judge concluded at paragraph 82. And then, to similar effect, if one looks at page 192, Some questions are asked.
I'm sorry, which page?
I'm sorry, 192 of the transcript, my lord.
Thank you.
And actually, if I could just ask you to look at 192 line 6 through to 195 line 2, please. So that cross-examination was in relation to the information memorandum, but the individuals concerned included the Sheikh Nayan, and Mr Modi admitted that he hadn't approached any of those proposed directors about being directors in Iron Care. So we do submit that on any view, paragraph 82 is erroneous. And another example of just a clear error in the judgment, again, if I could just show you the relevant part of the judgment first. I could ask you to look at paragraph 80. At the end of paragraph 80, which is page 96 of the core bundle, the judge says, in the end, this is the penultimate line, in the end, moreover, the claimants did not put to Mr Modi in cross-examination any alleged misrepresentations subsequent to the 13th, 14th April meeting. Now, your lordships know, because I've shown you this in the pleading, what was being said was that there were misrepresentations in the information memorandum as well. And as I said, ultimately, it was common ground that that was circulated on the 16th of April, so 2 days after the meeting. And the claimant's case at trial was that the information memorandum made misrepresentations which essentially reinforced the contents of what was said to them at the meeting. And in fact, the judge rightly identified, if one looks at paragraph 72, he rightly identified that that was the way in which the 16th of April information memorandum was being relied upon. Paragraph 72. First sentence, claimants relied upon the IM of the 16th of April as part of the alleged reinforcement. And, my lords, there was cross-examination of Mr Modi in relation to the contents of the information memorandum. Let me first show you, because I don't think we've seen it, but if I could just show you quickly one page of the information memorandum so that to put the transcript evidence in context. If I could ask you to look at the agreed supplemental bundle at tab 1, page 2, please. And I believe that this is just an extract of the document. Not all of it's been included in the bundle for this appeal. But the bit I'm concerned with is page 2. At the very bottom, you see boxes with compliance and legal. So legal is, again, Harish Salve appears, and Ronald Noble appears under compliance. And that was highly relevant because, as you know, Mr Salve, at least, was referred to in the IPD and the leadership board. And Mr Modi was cross-examined about the references to Mr Salve and Mr Noble in the IM. So if I could show you. Well, in relation to Mr Salve, I think I've actually taken your lordships to the relevant passage, but just again for your note, it's page 1, well, the cross-examination on the IM, let me show you that, begins at page 173 of the transcript.
Sorry, which day?
Day 4, I apologise. So that your lordships can see day 4, page 173, line 15. You can see the question about Mr Salve appearing in the information memorandum. And then the passage I think I took you to earlier is at 177 to 178 on Mr Salve. But if I could also show you what Mr Modi was cross-examined about in relation to Mr Noble, which I don't think we looked at earlier, page 178, Ronald Noble, had he agreed to work for compliance in Iron Care? No, not to my knowledge. I never asked him to be part of. I envisaged him to be compliant in the future, but I hadn't asked him. So, my lords, we say it was completely wrong for the judge to say there was no cross-examination on any misrepresentations after the meeting. And moreover, it was highly relevant evidence, which again was not taken into account. So, my lords, those are my submissions on the first issue, whether the statements were made. And as I have sought to demonstrate, we make two really fundamental points. One is, as a matter of substance, the conclusion that the judge reached, namely that the statements were not made in the terms alleged. We say that was an unreasonable conclusion. But we also make criticisms of the way in which these judgments have been put together, the failure to deal with evidence, the failure to separate out the legal issues, and so on.
Can I ask you a couple of things about that? You say the judge's conclusion was an unreasonable one, but I think you were accepting earlier that if the appeal were allowed, there would have to be a retrial.
Yes.
Is it implicit in that one could reasonably reach the conclusion that the judge reached? I mean, otherwise there's no point in a retrial.
Yes.
In which case, how can the judge's conclusion be an unreasonable one if it could reasonably be reached?
Oh, I'm sorry, I'm not sure. Sorry, my lord.
When
I say the conclusion is an unreasonable one, I'm using that as shorthand for it's a conclusion that no reasonable judge could have reached. So I'm using that as shorthand for the test, which I fully accept I have to meet.
So suppose it is a conclusion that no reasonable judge could have reached, then there'd be no point in a retrial, because inevitably a judge would arrive at a different conclusion. There'd be no point in trying it. But you accept that there would need to be a retrial. Is it implicit in that a judge could reasonably reach the conclusion that the judge reached?
Well, no, my lord. As a matter of law, we completely accept that we need to establish on this appeal that in relation to the facts, the conclusions reached were ones that no reasonable judge could have reached. Now, there are two ways of going about that in terms of the consequences. If your lordships are with me on that, obviously there are two options. One is to enter findings yourselves, and the other is a retrial. Logically, those are the two options. But we accept that in a case such as this, with one of the problems being the complete failure by the judge to deal with certain issues, we accept that a retrial would be necessary. I mean, obviously, if your lordships were satisfied to such a degree that these representations were made, then that's why the appellant's notice is formulated in the two alternative ways. But the case law does make clear that an appellant in my position, being realistic, needs to ask the court to send this back for a retrial. But that's not implicitly recognising that there...
Can I just take it a stage further? If you look at Henderson and Foxworth, one of the cases, where you get a summary at paragraph 67, this is page 76 of the bundle, the authorities bundle. Where Lord Reed says, in the absence of some other identifiable error, such as a material error of law or the making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of relevant evidence, or a demonstrable failure to consider relevant evidence, an appellate court will interfere only if satisfied that the decision cannot reasonably be explained or justified.
Yes.
Now, in what you've just been discussing, I think you're directing yourself at those last words.
Yes, although in certain places in my submissions I also refer to a demonstrable failure to consider relevant evidence.
I mean, if that point had force, then you might not need to satisfy the last part.
I understand. I understand. But my lord, one of the difficulties is we make, as you know, we make a number of criticisms of the judgment. So one, a lack of reasons. I think that was put as ground one of the original appellant's notice and skeleton. We do say in certain places he has made a demonstrable misunderstanding of relevant evidence, but and overall, we also say the ultimate conclusion on the first and second issues were unreasonable.
And just before you move on to your next bit of argument, can I ask one other thing? The judge has found not merely that Mr Modi didn't intend the words to be understood in the way that was alleged, but that Mr and Mrs Marg didn't understand them to be intended to be read that way. Now, you've taken us carefully to parts of Mr Modi's cross-examination. Should we be looking at all at what was put to the Margs? Was it put to them, look, you didn't understand these words to mean that these individuals had signed up, but rather you understood them to mean that they were part of the vision?
Well, I mean, your lordship obviously can look at what the oral evidence of the Margs was, but the overall gist of their evidence was that they understood them in the way in which it was alleged in the particulars of claim, and that was obviously rejected by the judge.
There's a slightly different point, not merely what the overall effect of their evidence was, but what was put to them. But it was put to them, was it, that they did not understand the words to mean these people had signed up?
I need to be slightly careful because I obviously didn't appear at trial, but from memory it was certainly put that all that Mr Modi was ever representing was a forward-looking position.
Yeah.
I have seen that in the transcripts, and I can give you the references over the short adjournment. Whether the precise formulation that your lordship has used was put, I'm not sure I'd be able to answer that fairly right now. But it was certain the overall case of Mr Modi, pleaded case, written evidence, oral evidence, was the vision, and that sort of case was put to the witnesses. So, my lord, I was then going to turn to the second issue, whether the judge was right to conclude that the presumption of inducement was rebutted. Now, the legal principles in this respect were common ground before the judge, and they're helpfully summarised in the judgment itself at paragraphs 35 to 37. Your lordships will obviously be well familiar with them, but just 4 points, if I may. First, there's no but-for test. Secondly, there is a presumption of inducement. Thirdly, the maker of the misstatement cannot say that the reliance was unreasonable or evade liability by saying the other party was gullible. And fourthly, there's no duty on the innocent party to carry out due diligence. And maybe I should just quickly look at. I'd like to take you to one authority just on the strength of the presumption, which is, it's tab 5, the Zurich case. Now, my lords, obviously, take a step back. One only gets to this question assuming the judge had found that fraudulent statements were made. And if I could ask you to look at, first of all, paragraph 34. Well, in fact, if we start at 33, you'll see the point about doesn't need to be the sole cause. At 33, this is page 92 of the authorities bundle. Sufficient for the misrepresentation to be an inducing cause, not necessary for it to be a sole cause. And then, if one looks at the quotation by G, The representation need not be the sole inducement in sustaining the loss. If it played some part, even if only a minor part, a causal connection will exist. So that's the causal test. But then the point which I would like to emphasise is the strength of the presumption in a case where it's been made out that a fraudulent statement was made. At 34, it's an inference of fact, and in the quotation from Chitty, the inference is particularly strong where the misrepresentation was fraudulent. 35, quoting from Lord Mustell in Pan Atlantic, the representor will have an uphill task in persuading the court that the misstatement has made no difference. There's a presumption in favour of a causative effect. And then the decision of Mr Justice Briggs in Ross River, he says, where fraudulent material misrepresentations have been deliberately made, there is the most powerful inference that the fraudsman achieved his objective, at least to the limited extent required by the law, namely that his fraud was actively in the mind of the recipient when the contract came to be made. At 37, since the issue was touched on in argument, I would simply say that the authorities seem to me to support the conclusion that it is very difficult to rebut the presumption. The orthodox view is contained in Sharland and Sharland, and then Smith and Kay. Lord Chelmsford, can it be permitted to a party who has practised a deception with a view to a particular end, which has been attained by it, to speculate on what might have been the result if there had been a full communication of the truth? And then Sharland and Sharland, Baroness Hale observed that it indeed held that a party who's practised deception with a view to a particular end which has been attained by it cannot be allowed to deny its materiality, or that it actually played a causative part in inducement.
So just pausing there, you possibly get two slightly different ideas there. In the first sentence, we get the idea that it's very difficult. And then in the quoted passages, we get the idea that it can't be allowed at all. So which do you say?
Well, I do accept that it's a rebuttable presumption.
Yeah.
But I do emphasise the strength of the presumption is such that judges are referring to it, as your lordship absolutely right. One does see references to essentially the misrepresentor being precluded from denying causation. And then again over the page at B, one sees a quotation from an article where the presumption is explained. The representor must have decided to make the misrepresentation. In doing so, they fashioned an evidentiary weapon against themselves, and the court should not subject the victim to what-if inquiries. So, my lords, we do say this is a very strong presumption indeed, and one has to remember the causation test is only whether it played a minor part. So it's a very powerful presumption. And then at 39, on a different point, I agree the representee has no duty to be careful, suspicious, or diligent in research. What is the duty of a man to inquire? To whom does he owe that duty? Certainly not to the person who had committed the concealed fraud. So that's a different point. But the victim of a fraudulent statement doesn't owe a duty to investigate, as it were, or do due diligence. So we submit that the judge's conclusions on reliance were again unreasonable, especially taking into account the high threshold. And if we first look at the judge's findings in relation to inducement specifically, so at 62 of the judgment, he says he wasn't persuaded by the joint insistence of the Margs that at the end of the meeting Mrs. Marg was already committed to a financial investment. And then he deals with reliance later at 81. He says, despite opportunities over some months to check or inquire on the progress of specific future investment promises, the Margs do not appear to have done so. So just to remind your lordship of the chronology, the meetings in April, the investments ultimately made in November, and here he's saying they didn't take or avail themselves of the opportunities to check or inquire. Then at 90, He says, as for the questions of reliance and causation, it's inappropriate in the light of my above finding to rehearse extensively all of the arguments. However, in case I'm wrong, they were false men made, and I'm doubtful that they were relied on. And then at 91, as regards reliance, I've reminded myself that in a case of deceit, there's a presumption of reliance, and the burden lies on Mr. Modi to rebut it. This is not an easy exercise. And then over the page, I would be tempted to find that burden discharged. Now, we would respectfully suggest that's in fact not a finding. He is not saying that the burden has been discharged. He's expressly saying something to the contrary. At 92, he then says, while Mr. Modi's case before trial may have exaggerated the extent to which they were actively involved, they had access to staff, provisional accounts and other information. And then he says they didn't express any apparent concern as to who else from any large and hopeful earlier pool might still be in the pipeline for later management and leadership or brand roles and or share investment. So he does seem, in 81 and 92, he does seem to be saying, contrary to the authorities, well, they failed to carry out the necessary checks. But
Sorry, go on.
When you say contrary to the authorities clearly established that as a matter of law, you don't have a duty to make inquiries.
Yes.
If you've been deceived, then the fraudster just has to take you as you are, and if you don't choose to check, then that doesn't avail him. But as I read this, the judge is making a different point, which is not a point of law at all, it's a factual point. And you might have thought that if that's what they really understood from the meeting, and it was something that was of sufficient interest to them to rely on it in some way, you might have thought that in all the inquiries in the ensuing months, they might have followed up on those things. Now,
Yes.
that doesn't seem to me to be a legal point, but just a factual point.
No, but the legal point is the starting point is that assuming there is a fraudulent statement, there is a presumption of inducement.
Yes.
The burden then shifts, and the question is, has the burden been discharged? And if one looks at, and as a matter of law, there, as your lordship says, there's no duty to carry out due diligence. But if one looks at 81, he's saying the Margs don't appear to have availed themselves of opportunities. So the submission is, well, how is this failure to carry out checks over the coming months, subsequent months, how could that possibly be sufficient to displace the presumption? That's the submission. So it's not so much an error of law, my lord. It's a failure really to, the conclusion that the burden was discharged. Well, we say there was no actual ultimate finding that the burden was discharged. He simply says, I'd be tempted to find. But secondly, we say the material that he was referring to would not be sufficient to displace the presumption. But then what happens in the supplemental judgment when refusing permission to appeal, paragraph 13, page 112 of the bundle, he says what matters more, perhaps, is that they did not prove that they understood and relied on the IPD at the time. On the contrary, if it indeed would help Quantum better to understand my judgment, I can say plainly that I did not believe the Marg's evidence to that effect. Now, just pausing there, we submit that that is a surprising strengthening of the conclusion between the first judgment and the second judgment. It doesn't seem to be supported by any new reasoning. And he then says it's possible that the document only became part of their case on deceit later. And in relation to that, we say that was an inappropriate thing for the judge to say in circumstances where he found that they were right, that the IPD had been shown to them at the meeting, and Mr. Modi's case to the contrary was rejected. Okay, so
can I just sort of try breaking it down? As you say, he found that a document along these lines had been used at the meeting, but there was a hard copy.
yes,
So it could conceivably be the case, could quite easily be the case, that there had been a hard copy of the document at the meeting, but they'd forgotten about it, hadn't attached any particular importance to it, but then had been prompted to think about it by discovering what was in the Dropbox. A slightly different point is that the judge seems to have rolled up together what the representation was and whether there was reliance on it. And you can't, I mean, I suppose one reads that as saying the Modis didn't, the Margs didn't understand the representation in the particular way. But even if they did, they didn't rely on it. But it is all rolled up.
It is. I mean, that's our basic complaint about all of this. This doesn't appear, as I say, in the first judgment. So we're having to try and put the two judgments together on this question of reliance. In the first judgment, he's actually run together reliance and whether the representation was made. And he compounds that error we submit in paragraph 13. But your lordship will recall it's not only...
Can I just pause there? I think there's a danger of confusing reliance in two different senses. The presumption of reliance, which you've been addressing us on, is that when you come to do something, the misrepresentation is an active part of your decision making and the thing that was done here was to get Quantum to put $1 million into Ironcare. And that, as we know, was some months later in November. Now, in that sense of reliance, that's where the presumption comes in. Yes. If you once have a deceitful statement, you assume that it is operating on the mind of the person deceived when they make the decision in November. But I don't think that's what the judge is talking about at all in this sentence, in supplemental judgment, paragraph 13. I think he's talking about what they understood at the meeting in April that Mr. Modi was saying to them. And he says, I didn't believe then when they told me they understood the IPD as meaning that these individuals had already committed. And that's not a new finding. He'd said that in the judgment of paragraph 89 when he'd said, not only did Mr. Modi not intend that meaning, but it wasn't understood by the Mags as meaning that. Now, if he's justified in making that conclusion, then reliance doesn't come into it because you don't ever get to a stage of the Mags having been deceived in the first place.
The reason, my lord, I take issue with that reading of the paragraph is the understood and the relied on the IPD at the time as meaning that the individuals. It's the reference there to reliance.
Yes, but you have to read that with the words at the time. And I read that as meaning in April, at the meeting on the 13th and 14th of April. In other words, he showed us the pack, which was either the IPD or something like it, and we understood from that, and we relied on that night as meaning these people are on board, they are committed. Well, and it's that which he's rejecting, and has rejected in the judgment. And unless you can persuade us that that was a conclusion he couldn't reach, then the reliance doesn't actually arise, which is why he says, in that slightly tendentious way, I would be tempted to say.
But my lord, if your lordship's reading of that paragraph is correct, then in fact the position is even more favourable to my clients, because the judge has stopped on that basis at saying I'd be tempted to find the burden discharge, but he hasn't actually made that finding.
Well, that's because on his finding there wasn't a deception at all.
Well,
and in that sense, he's right. He can't actually make a finding as to whether they relied on it, because obviously they didn't, because they weren't deceived at all.
But then, my lord,
that's why he says in 91, it's not an easy exercise on the hypothetical assumption that Mr. Modi made the representations contrary to my finding, because you only get to the presumption of reliance if you're satisfied there's been a fraudulent misrepresentation.
My lord, with respect, that is a point in my favour. If your lordship reads the two judgments in that way, that's a point in my favour, because then that makes the case for a retrial.
Well, I think
there is no finding on reliance,
yes.
and therefore all your lordships need to be persuaded of on this appeal, on that basis, is that the judge, I'm right in so far as I've criticised the findings as regards whether the statements were made. Because if your lordships...
But it's not just whether the statements were made, but how the Mags understood them.
Yes, I'm sorry, but that's all part of the same question. Legally, there's one issue there, which is what statements were made.
They're two separate questions. I think they're... What did Mr. Modi mean? Or how did the Mags understand it? And I'm not sure they are quite the same question.
But my lords, if one's asking what's the question for the judge in relation to which those are issues, the question is what were statements made in the terms alleged? That's the ultimate question which the judge is seeking to answer. Now, within that question, there may be issues as to what the representor was intending and what the recipient of the statement understood. But ultimately, the overall question is, was the representation made? I mean, the way in which the elements of deceit are always explained. One, was a statement made? Was it false? Was it knowingly false? Was it made with the intention to induce? Did it in fact induce? Did it cause loss? So the element of the tort to which all of this is going is, was the statement made in the terms alleged? Now, if your lordship is right, that the judge has not tried to strengthen his conclusion, because we say it wasn't a conclusion or finding on reliance in the first judgment, he specifically addresses the presumption and says, but I'm tempted,
Yeah.
but he doesn't say anything further than that. If your lordship is reading the supplementary judgment as saying, in fact, paragraph 13 is just about understanding, so whether the statement was made, then my lords, my job is easier, because then all I need to persuade your lordships of is that the judge reached an unreasonable conclusion or failed to consider relevant evidence and so on the first question, were statements made in the terms alleged? And if so, then plainly we would respectfully submit this case needs to go back for the presumption question to be looked at again, alongside the representation question. The reason, my lord, just to explain, if one looks at paragraph 5 of the supplementary judgment, you can see a summary of the complaints that were being made by the claimants at the permission to appeal stage. And
Yes,
they
I see.
said the absence of reference to or reasons for the rejection of written representation case, and these matters are of fundamental importance given the acceptance of the falsity and the absence of a finding that there was no reliance. Now, if in fact the judge has not sought to cure the absence of a finding on no reliance, then as I say, this appeal ultimately boils down to whether the judgment on the first question can stand. Because he hasn't even gone on to make findings in relation to the other issues. My lords, I was going to come on... Yes, exactly. I was just going to come on to start to make my submissions on the finding of the presumption. Sorry, my lord.
Forgive me, Mr. Singler. If you were moving on anyway, can I just take you back, please, to the main judgment?
Yes.
At paragraphs 89 and following, just to see what the analytical structure of the main judgment was, so I can be clear. And please do correct me if I'm wrong, but the way I understand the structure of the judgment is that paragraph 89 is the critical reasoning, and the judge makes three findings there. That the quantum has not proved that Mr. Modi made material misrepresentations with the meanings it alleges. Secondly, it hasn't proved that he intended. And thirdly, that the Margs didn't understand those to be the meaning. So that rightly or wrongly, that the judge understood to be all contained within what I think we've been calling on this appeal the first issue.
Yes.
Then, and quite distinctly, the judge moves on to the question of reliance. I'll leave aside causation for the moment, because it's reliance we're focusing on. He then turns next and distinctly to the question of reliance in paragraph 90. And as my lord has been putting to you a few moments ago, in the next two paragraphs, he finds that not an easy exercise, because it's a hypothetical one, and it could be said that he doesn't actually make a firm finding at the end of the day. And I know you criticise him for not doing so, but if his conclusion at the end of paragraph 89 were ultimately thought by this court to be sustainable, I know you attack it, but if you lost on the first issue, then wouldn't that be the end of the case?
Yes, no, obviously, my lord, we completely accept that we need to win on the first issue, because otherwise the question of reliance...
So the mere failure to make findings on the question of reliance, you accept that that wouldn't assist you, unless you have first succeeded on...
Absolutely. What I was, just to explain, the target, as it were, that I was attacking were insofar as he's made a finding that the presumption of inducement was rebutted, we say that was just unsustainable for reasons which I'll develop after the short adjournment. I think Lord Justice Nugee was raising with me whether, in fact, the supplementary judgment does go further, or whether this is all we have in relation to the presumption. But can I just before we do rise, can I just draw your Lordship's attention to 31 of the judgment, where he sets out the legal principles which were agreed and are consistent with what I've been trying to articulate this morning, which is the elements of the tort. A, the defendant made a representation of present fact which was false. That's why I say, to Lord Justice Nugee's points and also Lord Justice Singh, at the end of 89, when the judge is talking about whether he intended or the margs understood, that's all, in my submission, part of A in 31.
Yes,
My Lord, that would be a convenient moment.
In which case, we'll start again at 1:45.